IP, of course, refers to creations of the mind, if you like. It's one way of describing it, such as inventions, literary and artistic works, design, symbols, names, images, anything like that that is used in the commercial world. It's a vital asset, one that's frequently overlooked, and it can represent a significant portion of the value of your business. So we are going to hear why IAP is important, both to protect you, give you a competitive advantage, to hopefully generate more income for your business and for brand identity. Throughout this workshop, we'll explore all the different types of IP, how to protect them, strategies to leverage IP for your own business growth. So let's get started. And I'm delighted to say that today we've got Jerry Bridge-Butler with us from Baron Warren Redfern, who's going to help us to get to grips with all the really important aspects of business in regards to IP. So let's, just before we begin, I think it would be really helpful, appreciate Matt. I'll give you a heads up, Matt, if you could just do a bit of typing for me into chat and I'll read it out. If we could just introduce ourselves, where we're from and the nature of the business, just because it would help all of us as to who and what and why you're here. So just to get started, I'm Heather Dean. I'm Head of Skills and Business Support, as you can see, at Buckinghamshire Business First. And therefore oversee all of the support that we provide and the skills support for both businesses and for those still in school or education. Jerry, over to you.
Hello, Matt and Rita. I'm Jerry Bridge-Butler. I'm from Baron Warren Redfern. I'm a chartered patent attorney and chartered trademark attorney. Yeah, so I deal with the whole gambit of intellectual property, helping businesses protect every aspect of what they do.
Thank you, Jerry. Rita.
Hi, everyone. My name's Rita Hemraj. I am a business improvement specialist, so I use a methodology called Lean and provide consultancy services to, for example, optimize your processes, reduce costs, and make people help unblock things so people can make more money, essentially, in businesses. Okay. I'm quite new starting out.
And therefore IP is probably most important to you right now, so welcome to this meeting.
Thank you.
Sarah is sitting in the background, who's going to support me if any of our systems break down. Hopefully she will rush in and support us. Matt is typing, and so I'll just wait for his response. I bet Matt is on a mobile phone, so what I've just asked him to do is probably even more awkward than it would be normally. Okay, so particularly interested in IP to protect software. So Jerry, I'm going to hand over to you, if that's okay, and say over to you. And if you want to take control of the slides, the stage is yours.
Thank you. Thanks for the introduction. Hopefully you can all see that on the screen. This presentation is a kind of overall view of intellectual property and the different ways you can approach it to improve your business situation. But given that there's so few of us, it would be quite good if we could, make it quite interactive. So if you have any questions, just literally just type them out or just shout out. It might be easier to do it that way. Because I might go off starting talking about stuff which is not particularly relevant to you guys, or if there's things that you'd more rather hear about, then we can go into that. So maybe what I'll do is I'll go through the slides fairly quickly, and then we can have discussions about some of the things that are of particular concern to you. Rita, from your perspective, if you're helping businesses, then we work with a lot of people who do what you do, in the sense that a lot of our clients come to us through business consultants. Who are helping those businesses to improve in one way or the other, and then the IP is one aspect of that. So it's almost like having a good understanding of it, so you can integrate it into your thought processes and the things that you talk with your clients about, is kind of most important. So having an understanding of how they can use IP to better their business is quite important, rather than it being your own business. And as for IP and software, I don't have any specific parts of this presentation that deal with that, but it is a very interesting topic, so we can talk about it some more. I'll try and mention it as we go along, if I think it's particularly relevant. So just a little bit about my firm. We're a medium-sized law firm of intellectual property attorneys, so all we do is IP. We don't do anything else. We do help our clients with some other legal things, but it's usually by referring them to other lawyers that we work with. We can handle all elements of IP protection in the UK, Europe, and all over the whole world. So we're part of a big international network. So that's quite important. So any business that has an international view, you can channel everything through a firm like ours. All IP attorneys in the UK are like this. We work with US attorneys, Chinese attorneys, things like that. So you can have a point person here in the UK. We're not particularly large, but we've been around for a long time. We've got offices in Brentford. We're not actually no longer in the Future Works in Slough, so that's actually slightly out of date. But we were for some time. It was an interesting place, Future Works, if you've come across it. It's full of startup businesses and lots of interesting stuff going on. So this next slide, in some of my presentations, I break this up into lots of different slides, but I want to just have one and just go through it relatively quickly. I'm presuming that you have some basic understanding of intellectual property, but what I'm doing here is I'm just explaining what the 4 core elements are that you need to be aware of. And each one of these core elements is completely different to the others, and they protect businesses in completely different ways. So what things you need and what things you apply for and you have will depend on the nature of the business itself and what kind of protection you're actually seeking. So the first one is patents, and that's the thing people often think of first of all when they think about intellectual property protection. And that's mainly because patents are the most powerful kind of intellectual property you can have, because they can protect an invention in broad terms, which can give you a lot of power if you have a very important invention. They only relate to technical inventions, and there's a very important point about whether they cover software or not. The patent system is set up to give people exclusive rights to use an invention for up to 20 years. And that's bad for society, good for the inventor. So it's bad for society because the rest of us can't use the invention. So the whole point about it lasting 20 years is, or up to 20 years, is that when the patent has lapsed, anyone can use the invention. So a notable example of that would be Dyson and its vacuum cleaners, its cyclone suction vacuum cleaners. The patent ran out, and now everyone can make those things. That's how it works. But because they were trying to balance these rights that they were giving, these exclusive rights, there's a list of things which you can't get patents for. And specifically, that includes business methods, mathematical methods, medical treatment methods, and computer software as such. And that computer software as such exclusion is very problematic for everyone who's in IT, because you can't get a patent for just a computer program, because a computer program itself, in very broad sense, is just a list of instructions. But what you can get patents for, and we do a lot of work in this area, is for computer implemented inventions. So you have to have more than just a piece of software. If there's some kind of physical thing happening, anything that you might term as the Internet of Things, or stuff which is just apps that just give you information, or portals that facilitate business transactions, that kind of stuff is all ruled out. But there are plenty of examples of people seeking rights for those things, because the definition of what you can and can't get is actually quite fluid. So we do work with people who push the boundaries quite a lot. So it's a very interesting and in-depth area. And if you start going into AI and stuff like that, it gets even more interesting. But the basic rule of thumb to start with is that you can't protect computer software. It's got to be a computer software implemented invention, and it does vary case by case. Patents are crucial for businesses which invest a lot of money in R&D. So if you have a business which is investing heavily in producing something, then you need to guarantee a return on that investment, and that's what patents are for. So you can see it working very well with something like pharmaceuticals. So a pharmaceutical might cost tens of millions of pounds to actually create and clear and get on the market, but it could be very, very simple, and it could be very easy for someone to copy. They can copy it in 5 minutes once they see what it is. So the patents are there to allow someone to invest all that money and be confident that they will get a patent at the end of it and then be able to exploit that for a period of 20 years until they have to let everyone else use it. That's basically what it's for. The invention has to be entirely new, and it has to be inventive, and these are very difficult thresholds to get over. So it's difficult and complex to get patents, generally speaking. Application process takes several years. There are high ongoing costs. There are costs when you file the application, costs when you're dealing with the examination stage, costs when you get it granted, depending on the jurisdiction, and then you have to pay a cost every year to keep your patent alive. So if you have 20 patents in 20 different jurisdictions around the world, you're spending quite a lot of money all the time. And you have to balance that against the benefit that you're getting. So if it's guaranteeing you a much larger share of the market, then obviously you would keep the patents. But if you weren't making the products anymore, you stop paying these renewal fees and the patents die. Hence, they don't last automatically for 20 years. They last as long as people keep paying for them. Generally speaking, you're looking at an upfront of investment of around about £5,000 to start the process. And that cost is basically what it costs to draft the patent application, which is a very complex thing. It takes a very long time. Once that's done, you can then use the same document to apply in other jurisdictions. It says their typical total cost 10 to 30k, depending on the countries. Yeah, you can, over about 3 or 4 years, if you've got an invention that you're patenting in Europe, China, US, for instance, you could spend up to £20,000 or something like that over that period of time. That's the level of investment you're looking at with patents. So that has to be factored in as to whether it's relevant for you or not. Trademarks, completely different from patents. Trademarks protect brand names. And so every business which is in business should be interested in protecting its trademark, because every business has a name and you don't want other people to use that name. And you don't want people to be confused into thinking that someone else is you. That's what trademark registration is all about. It's giving you that exclusivity to be the only party to use that particular trademark. Trademark registrations last for 10 years at one go, so you only have to renew them every decade. In order to get something registered, there's certain requirements. The mark has to be distinctive, which is to say it can't just describe what the goods and services are. So somebody can't use the trademark umbrella to sell umbrellas because that's what they're called. So you have to come up with a distinctive trademark like Adidas for clothing, for example. It's relatively inexpensive compared to other types of IP to get. At my firm, if you were to use us, if you're using professional representatives to prepare and file the application and deal with all the elements of the application process, it's £1,245, just to give you a flavour of what you're looking at, but that's the kind of cost that you'd be looking at. If you wanted to register it in multiple different jurisdictions, it's a very vague cost I've got here, £4,000 to £5,000 for 3 to 4 jurisdictions. You get the idea. It's generally about £1,000 a place. We have clients who register their trademarks in 40 or 50 territories around the world, so they spend a lot more money on it than that. But it all depends on what you're doing. And there's no point in having trademark registrations in territories you're not trading in, because it's a bit like having insurance, car insurance for a car you don't have. You only really need it in places where you're actually doing business. So a lot of the time, it'll just be the UK. A lot of our clients will have UK and US or UK and Europe, but there's a European system. Designs are also very, it's worth knowing a lot about registered designs, because again, they are very different from patents and trademarks, and they protect businesses in different ways. What designs do is that they protect the aesthetic appearance of products. So not how they work, which is what patents are all about, and not their name, that's trademarks, but simply what something looks like. So they're very valuable to businesses who invest a lot of time and effort into creating a good looking product, but they're not inventing anything new. So somebody who makes watches, for instance, or jewelry or cutlery or something like that, where there is a lot of value associated with the appearance, and you can protect that with a registered design. They are becoming, or have become, very, very relevant in recent years, because you can enforce them on platforms like Amazon and eBay and Etsy, whereas you can't enforce patent rights very easily on those platforms. So if you're making a product which you're going to sell on a platform like that, and the risk level to you is quite high of somebody selling counterfeits on the same platform, then registered designs are really, really relevant. And unfortunately, if you don't have a registered design for your product that you're selling on somewhere like Amazon, then what will unfortunately happen to you is that somebody else will make a counterfeit version and register the design themselves and destroy your listing and take all your customers, which is a really awful thing that happens. So depending on what the business is, what you're doing, that can be incredibly important. Designs still have to be new when you apply for them. It can't just apply for something which is already there. It's relatively inexpensive. It's what's called a deposit system. You just apply for it and you get the rights. So it's your responsibility to make sure that they're actually valid. So it's relatively cheap. It's about £545 for a single UK design application using us. So it's not expensive at all. So that is something to really think about a lot, depending on what the business is. The final type of IP is copyright. Copyright exists automatically, so you don't have to do anything to benefit from it. It comes into force as soon as an original work is created. It's of prime relevance to all businesses that are in media. So all media businesses, their entire business model is based 100% on the laws of copyright. If copyright didn't exist, then the business would not exist. So all of publishing, music, and film is based around copyright, because what copyright does is it gives the owner, so the originator of the work, the exclusive right to make copies of it. If you didn't have that, then as soon as a publishing company published a book, someone else could just reproduce it and sell it. Or if you brought out a song, someone could just reproduce it and sell it. So copyright is there automatically. You don't have to do much, but there are lots of very important elements of it that we get involved in, and it's normally around ownership, making sure that the ownership is correct, because a lot of the time it isn't. You need to make sure that is really done properly. And if you are a business that commissions stuff to be created for you, such as logos or content or websites, you need to make sure that all copyright is assigned to you, because otherwise you can have a lot of problems with that. Also with contracts and licensing. So a lot of copyright forms the basis of license agreements, contracts, that sort of stuff. So we get involved with it at that kind of level. Right. So what I'm going to do is I'm going to go through how people normally approach IP, and perhaps some better ways of approaching IP to build stronger businesses. So what I've done is I've created a fictional example of a business that's decided to make a product. And in this case, I just chose a torch. So you can see the picture of a torch. Now, the conventional way that people seem to approach intellectual property is as a secondary thing that they only think about after the event. So they will decide to create a business, whatever that business is, and they will do all the work associated with that. They might even get, if they're going to make a product, get the design done, the tooling done, and even get the product made. And then just before they start, they think, oh, maybe I should protect this in some way. Well, that's fine up to a point, but as we shall see, that can create some weaknesses, that you could have avoided. So let's imagine that somebody's created this new torch and they have invented some new technology that goes into it. So I've written there, inventive rechargeable power supply, which lasts 25% longer. So let's say they came up with some technical invention that they thought, oh, this is a new invention, and I could apply it to something like a torch. They've had a new distinctive design made. They either did it themselves or they had a designer create a distinctive look. So this torch looks in a particular kind of way. They may have come up with a brand name for it. And what they've done is they've bolted on their IP as they think it's necessary. So they might go ahead and file a patent application. Normally people will do this in this kind of situation without really knowing if they're going to get anything from it. They're just doing it because, well, I've done this work already. I've got to this point, so I should apply, rather than thinking, well, is this the sort of thing that I can get patents for in the first place? They could apply for design rights. That's available to them. You can apply for design rights up to 12 months after you initially sell a product. So that is a bit different to patents, because you have to apply before you make the invention public. And they may apply for trademarks, but often people will come up with a brand already, maybe even using it already, and then they say, oh, I need to get a trademark registration for this. Well, that is a particularly problematic way of going about it, because you could have a lot of problems with existing rights that are already there that belong to other people, which is a massive problem. And going about it this way means you only get sort of what's available, rather than using the system to your advantage. So you end up with a business that looks like this. We've got the business in the middle, and you've bolted on the protection that you can try and get out of it. So a lot of the work we do with new clients sort of looks like this, because the client has already got themselves into a position where they're dead set on the product, the brand name, and the design. And so we say, okay, fine, well, let's see what we can get for that. Now, there's nothing intrinsically wrong with this, I suppose, but it's just the conventional way that things are done. And, there are a lot of potential problems associated with it. You can have all kinds of issues. You can end up getting into disputes with other rights owners, and you can end up getting lesser rights than you perhaps otherwise could have got for yourself. And in the worst case scenario, you might even have to reverse. So you might have a problem with the brand name. Someone might say, that's my brand name, you can't use it. So you have to go and change to something else, which can create a massive problem. You could have issues like you didn't get the copyright in the design assigned over to you. You could have issues with your patent application not being relating to something that could be granted or whatever. So let me just, I have to get familiar with my slides here. perhaps a better way to approach this is, instead of building a business and then saying, what sort of IP should I have? Actually ask yourself the questions at the beginning. What kind of protection do I want? How do I actually want to protect myself? And that comes down to looking at the nature of the business itself and what are its weak points and what are its strong points and what needs to be protected and what doesn't need to be protected. What are the USPs of the product? What is it that someone's going to want to copy? Is it the whole thing, or is it just one element of it? If you zero in on that, that can help define what kind of protection you're going to get. The other thing is, what is the main threat? I've already touched on the issues that can be associated with having a simplex product, which could be the subject of counterfeits that could sell on Amazon. If your main threat is that kind of thing, then designs start to become very important. If your main threat is a legitimate rival business of yours that you know very well, who likes to copy your ideas generally, but comes up with its own brand names and its own designs, but tends to copy your product ideas, then patents are much more important to you. So you have to look at the landscape around the business to decide what's actually relevant. Another factor is, what can you actually afford? Because all of this IP protection costs a lot of money. It costs a lot of money initially, and it can cost a lot of money over a period of time. Now, that can be put on a spreadsheet over 5-10 years. You can sort of predict what the costs are going to be. You can do all kind of stuff like that. But you need to look at it that way. Don't just launch into it and just apply for stuff and then at the end of the day say, oh, that was so expensive, I didn't want to spend that much. You need to do it the other way around. A business needs to say, how much do I want to spend on my intellectual property protection? What's an appropriate amount? And then if you do that over 5 years, you can then see what kind of budget you've got, look at the IP requirements and prioritize them and do them in the right order. Sometimes businesses are insulated in other ways. For example, I have a client in medical tools. Often you'll have a situation where someone has gone to great lengths to get their equipment cleared, and they're the only party that can actually supply this product, and no one else can actually do it because of regulations. Well, in a situation like that, maybe IP is less important, because you don't need to have IP to stop people competing with you, because they can't compete with you anyway. So there are other things to consider. Investment and exit strategies become more and more important for a lot of business models. If you're working with startup businesses, they will, almost all of them these days, have some kind of plan to sell it in 5 or 10 years' time, rather than in the past, most people would set up a business just to set it up and get it going and then to live on it and then see what they're going to do with it later. But if you're thinking about getting investment for starting up a business or for exiting from that business at some point, the IP starts to take on a whole new role. And it's all about adding the value and making sure that the right things are there. Because when you come to sell a business, the purchaser is going to get their lawyers to look at your business and try to work out whether all the intellectual property that should be there is there. And if it isn't, they'll just devalue your business. And I've seen big deals collapse because the IP wasn't correct. So if you're thinking about it that way, and also, you know, if you're approaching an investor and saying, I want you to invest £50,000 in this startup business, they're going to say, well, what's the guarantee on my investment? Have you got the intellectual property that's going to give you the maximum opportunity to thrive? If you don't have it, they're not going to invest. If they see that you've got the patents and the trademarks and the designs in place, they might say, I feel confident in investing in this business because I think the maximum opportunity is there. So again, the nature of the business, what its plans are, is going to affect how important, or how, you know, whether IP is more or less important to them. There are also tax benefits, quite considerable ones, depending on the nature of the business. Patent box tax relief in particular, you can halve your corporation tax payable on products that are sold that have a patent applied to them. So depending on what the business is, where it makes its products and so where it sells them, that can be of enormous benefit. So that's got nothing to do with stopping other people doing things with a patent. It's got everything to do with just getting this tax benefit. And there are also R&D tax credits and stuff like that. I don't know that much about that myself. Normally it's accountants who deal with all that kind of stuff, and we have a lot of contacts who we pass people on who do this sort of thing. But that is a very relevant consideration for a lot of businesses. This just follows on from what I was saying about what you actually get from these different areas of IP and what's relevant to a particular business. But essentially, you can see these bullet points here. It's all about increasing sales, building your reputation, protecting your reputation, you know, generating license revenue and stuff like that. There's so many benefits from having IP. Now, if you had the whole gambit, you would have all kinds of benefits. But it's really a question of looking at that and saying, well, what's most important to me and what kind of benefits do I want and what am I going to get for my investment? So if you apply a strategic approach to the business that this imaginary business, rather than just bolting it on willy-nilly, you might find that there's a particular path that reveals itself that's particularly relevant. So in this particular case, it could be that we decide that the invented technology is unlikely to get a patent because we've done some searching, we've done some research, and we decide that we're not going to file a patent application, spend money on that because the threat is not really there. And so it becomes relevant in this example to obtain design rights in the key jurisdictions instead. So we think that a key point about this particular product is its look, and that's what's going to make people want to buy it. And it's all associated, it's all tied in together with the branding and the marketing and the advertising. So design rights start to become particularly relevant. And maybe we're at a point where we can choose a distinctive and registrable trademark rather than just going with something somebody's already started using. So if you start applying strategic IP thinking to a business rather than just bolting stuff on, you end up with a business that looks a bit more like this. So you start off with your business on one side, you think carefully about what kinds of IP you actually want that's relevant to you. In this illustrative example, trademarks and designs are particularly relevant. And by going through those routes, you end up with a stronger business. You focus your resources on those things. And that's just a better approach, generally speaking. And if you employ an IP attorney such as me, then that's what the process you should go through. An attorney should look at the business and not just take instruction and go ahead and file this. Okay, fine, I'll do it. You're supposed to look at the business and decide what's relevant and talk to the business owner and say, what's your budget? What are your priorities? Where are the threats coming from? Let's build an IP strategy for you. So that's really a much better way of thinking about IP. Don't just go for everything that's available. Think about what's actually relevant, and you could end up with a stronger business in that way. So what I want to talk about now is taking it to a whole other level, which may or may not be available to a lot of people, but it's really a way of thinking about IP right from the beginning, before you even start thinking about what the business structures can be. Now, obviously, that's relevant to someone who's at the very beginning of starting a new business, but it's also relevant to businesses that are branching out into new areas. So I have several clients who've done this, who are selling products in a particular space and they want to move into a different space. So they can start thinking about how they want to build that part of their business and thinking about the intellectual property right at the beginning, and actually building the business around intellectual property so that they end up with a very strong business. So they do things like they identify a potential market they want to go into. So rather than just saying, I want to make these sorts of products, you say, well, let's have a look at the market. Is there actually space there for me? Can I sell products in there? What sort of products are going to be made? You do your IP research on that market. So you find out who the players are and what kind of patents, designs and trademarks they actually have. And if you create a landscape view like that, you can often see where you could fit. You can say, well, this party over here is a major player. They've got certain patents on a particular kind of way of doing things. This other party over here, they've got patents on other sort of stuff. But if we move into this area with a new piece of technology, you know, we can avoid those patent rights and we can create some exclusive space for ourselves. So if you think that way, what you can actually do is invent and design for protection. Actually work out what's going to be patentable and what's going to be design registrable before you even start. And then when it comes to trademarks, you choose branding for protection. And that means choosing branding which isn't going to conflict with somebody else and which is very distinctive and is going to be very different and is going to be exclusive enough to give you better rights. So it's all about thinking about all this stuff before you even really start and then seeing how that feeds into the business. So in this example, instead of just designing a new product, you actually look at the new business opportunity. So you might look at the torch market as a whole and identify a gap in that market and where I'm actually going to go with it. Do a patent search to see what patents already exist out there or design registrations. You might research the target audience, which might feed back into how you design it. Is it going to be aimed at children? Is it going to be aimed at professionals? Is it going to be aimed at women, age, demographic, all that kind of stuff? That all feeds back into your branding and your design. If you get those things right and you target it the right audience, it will sell. If you get it wrong, then it just won't be as successful as it otherwise could be. And again, doing a trademark search to ensure registrability. I'm just going to pause a second to look at the questions.
So I think, Barry, you've just got one at the moment, which is from Santosh, which was the last one posted. IP
yeah, okay.
Financial services.
I might have to, because I'll come back to that when I'll rattle through the slides and we can come back to that. So those are very interesting points you raise. Yeah, it might be easier just for me to run through. So yeah, when at this sort of genius level of IP thinking, you have you've done all these things and you've invented to get broad patent rights by identifying those gaps in the market. You've designed in order to avoid other people's rights, etc., etc., and you've got all your copyright secured. So what you're doing is you're maximizing the opportunity and you're building a business with IP at its heart. And then you end up with a business that looks a bit more like this. You start with your business idea, you do your research, and then you actually invent specifically in relation to that research you've done. You do your distinctive branding in relation to the information you've acquired. You design the product in a certain kind of way. In terms of additional copyright works, you're aware of the IP that's associated with them. And then you've ended up with good patents, good trademark registrations, good registered designs, you've got the copyright secured, and you've ended up with a leading business. So there are businesses out there that fit this mold, where people have deliberately gone about it in such a way that they've ended up with a really secure exclusive business that nobody else can copy because they've put all the rights in place in all the places they need to, and they just thrive as a result of that. And it's not by chance. It's not because people just come up with stuff and then they go and bolt stuff on. It's usually because someone's deliberately done this. And I'll try and take you through a few examples of that actually happening in practice. So this slide is just following on from some of the things I've said about, what value do you get from these areas of IP? Well, patents attract investment, give you a clear exit strategy. Trademarks are mandatory for investment. Really, if you don't have a trademark registration, you're not really going to get any kind of investment. And it's all about avoiding conflicts with other people, and it's the same thing all the way down the line. So what I'm going to do is just run through some very quick examples of how people can go about actually doing this kind of thing in practice. So this is an example relating to a client of ours who makes collapsing tables. If you've ever been to a summer fete or gone to primary school, then you've probably seen these tables. The company that makes them is a company called GoPack, and it had a patent for the folding leg system of these tables. And the patent was coming to the end of its life. And they were benefiting hugely from patent box tax relief. And so they came to me and said, what on earth are we going to do? Because when the patents run out, we're going to have to pay loads more tax, and that's not good for our business. So they were coming at it from a slightly weird angle, but they were basically at a position where they were saying, right, we need to come up with a new invention that we can get a patent for. And what this example does is it illustrates to you how easy that actually can be. It's not it doesn't have to be this huge barrier where you say to someone who's thinking of setting up a business, well, you're going to have to go away and reinvent the wheel. There are things you can do to get patent rights, which are quite marginal. The requirements of patentability are simply that the invention has to be new and inventive. And if you're very canny about it, then you can eke out some space that you can get patents for. So in this particular example, what you're looking at there is the original patent that ran out. And very, very briefly, you've got these legs are based around having two U-shaped pieces of metal that are connected together at the bottom, which means that the bars at the top can be pulled apart from each other. And that's what facilitates the hinge. So as you rotate the legs around, one of the bars goes over the top of this structure you see there and slots into a socket, and that holds it in place. And then in order to fold the legs back up again, you pull the bars apart, pull the bar out of the socket and rotate it back round again. The problem with this system is that if you allow people to pull the bars too far apart, it breaks the spring on the legs and the legs break. So the original patent was, it had a sleeve attached to one of the bars and it ran through this track and it stops you pulling it too far away. So that's how that's how they built it for 20 years. What you're looking at there on the screen is all they had to do to get a new patent. So it's a very simple mechanism. It works in a very, very similar way, and it solves the same technical problem, but it does it in a much simpler way. And that design took quite a long time to arrive at, but it was done deliberately so that they get patents for it, and they were able to get patents for it. And what you're looking at there is the granted UK patent. And all they did is basically build a little wall opposite the socket. So when you're pulling the bar out of the socket, it can't go any further than the wall. And it's just a more ergonomic, more efficient way of solving the same problem. And because of that, they were able to reinstate their patent rights. They have protection again. They have patent box tax relief. So it's just an example of how you can invent to get a patent rather than the other way around of just inventing stuff and going, oh, I wonder if I can get a patent for this. There is a process you can go through. And if you use an attorney, the attorney can guide you through that. This is an example from another client of mine who makes soap dispensers mainly. They're the ones you see out in public spaces that have got the little blue teardrop window on them. So they're made goodness knows how many million soap dispensers and toilet roll dispensers and things like that. And they wanted to go into another area of sanitary wares, which is chemical dilution dispensing systems for industrial washing machines. So in hotels or whatever, you might have 10 washing machines. You don't just put the detergent or whatever in each one. You have a complex system that delivers it to all these machines. So it's a big business area for them to go into. So they were entering a new market. They did all their research. They discovered what patents existed belonging to the main players. And they came up with a completely new re-engineered way of doing this. And what that did is it gave them a completely unique product they could take to market. It was completely protectable because there was nothing else there like it. And it solved an awful lot of problems, and it gave them a massive competitive advantage. Now, I'm not going to go into too much detail about explaining it, but it's essentially there's a head that moves backwards and forwards inside that body, and it delivers different fluids to different outlets, and it does it in a very complex kind of way. But what it replaces is what you're looking at the screen there. So you used to have a great big piece of equipment stuck on the wall with loads of solenoid valves and manifolds, and it's a really complicated, ancient piece of engineering. So the whole market was based around this ancient way of doing it. And what the client did is looked at that and said, well, we can see some IP in that, but we're going to do something completely different. And because they went about it in that way, because they identified the gap, they were able to design around all the IP that was there and come up with something that was completely different and much, much better. And that's just an example of how you go about doing that. Here's an example relating to branding. So this particular company makes skiing clothing and snowboarding clothing and stuff like that. And when they originally started, they wanted to call themselves Surface or Surf Ace. And they immediately came into problems with that, because there were a lot of other companies out there that were using that mark to sell similar clothing. So they had immediate problems with it. So they actually came to us right at the beginning, and we were able to talk to them and say, well, you need to come up with something a bit more distinctive. And if the more distinctive your branding is, the more different it is to other people, the fewer problems you're going to have. So they came up with the brand name Sophanic, which is a brilliant trademark from a registrability point of view, because it's not like anything else that exists, and it's very, very distinctive, and it also still resonates with the target audience. It has something evocative about it. It's got the word surf in it. It sounds a bit like the word satanic, I guess, but it's kind of cool, and it's, they've been a successful business for a very long time as a result of that. So it just shows you that if you do your research and you see what's actually out there and come up with something distinctive, you can make your legal life a lot easier and cheaper than if you just launch into something with a really obvious kind of brand name or a descriptive brand name that can cause you all kinds of problems. This is just a very quick example of a business which also benefits from a lot of good protection because of the way it went about it. This is a company called Little Hot Dog Watson that makes hats for children. Now you might think, oh, hats for children, how on earth are you going to protect that? Well, what they did is they came up with very distinctive pattern designs, and they applied them to the product. So the shape of that hat that you see in the picture isn't really protectable. It's a cap with a flap down the back. But what's very distinctive about this product and what's very protectable is the pattern that they applied to it. So they had about 5 or 6 patterns. This one was banana pattern. They had penguins and pandas and various other ones like that, but obviously appeal to children. But the very distinctive nature of those designs it was possible for us to register those. Now in the UK and the EU, you can actually protect just a repeating pattern as applied to anything. So a business like Cath Kidston, for instance, might have registered designs for all those patterns. And it's a very broad way of protecting yourself. So it means that people can't sell competing products that look like that. They could sell competing products that were hats, but not the ones that look like that. And they came up with a very cool piece of branding, Little Hot Dog Watson, which I think is quite cool, which, again, it ekes out an area of exclusivity for them. People can't compete with, they can't use that trademark. So if that trademark becomes the one that's associated with the products and so on and so forth, then, they end up with that bubble of exclusivity around them, and their business can thrive as a result.
Jerry,
yes.
Can I just interrupt you? So sorry, there's a question for you. It's going back to Sophanic. So before you go on too far, Rita's got a question for you, saying, did they do the protection of the name in advance of setup or afterwards? I.e., did they have to switch names or didn't go for the original one?
Okay. In this example, what actually happened was they had to switch, but they did it at a very early stage. So they had got themselves into trouble because they had approached IP in the manner I described at the beginning. They had simply set their business up, they'd decided on the name, and they'd started. and they decided to bolt on trademark protection pretty quickly afterwards, in the next month or something. But when they came to see us, this is years and years and years ago, I remember they came in and said, we've immediately got a problem. We're in this situation where we've started and we've realized that the brand name is problematic. It's going to be difficult for us to protect it. Other people have got it and so on and so forth. So at that point, we're able to say, well, why don't you reverse out of this and think of something else? So I think this example just shows you what you need to do to end up in that stronger position. Now, what would have been better for them is if they hadn't already started, if they just come to me straight away and say, we were thinking of setting up this company, help us with our branding. And a lot of clients do come to me in that way. And we can sort of guide them around the branding ideas they've got towards one that's going to be most registrable. So they didn't do that in that particular instance, but it just shows you how you can go through the thought process of starting off with a brand that isn't actually going to work and then ending up with a brand that does. And then they benefited from that. So they didn't have to do too much in the way of rebranding and changing and things like that from memory. But in the last 2 years, I must have helped 4 or 5 other companies in clothing who did have to change, sometimes up to 12, 18 months after they started. And that's just an unbelievable pain. It's very, very difficult. It's expensive, and you've got legal pressure on you because the other party is threatening to sue you the whole time. So you're having to negotiate your way out of it. You might have to pay them some money, stuff like that. So it's a bit of a nightmare, but you can avoid all of that. You really can if you just talk to someone right from the get-go. So any business, Rita, that you encounter that's got a brand name already and they haven't got their trademark sorted out, then it's an alarm bell that goes off. You need to go and speak to someone straight away about it. Is it protected or not? Even if someone says, oh, I applied for that myself, it's fine. No, go and have an attorney look at it. The amount of times I've seen what people have applied for themselves and they got it all wrong, it's something you just need to straighten out. So that's what that example is all about. I want to end there. I've got a bunch of other slides, but I won't bother going through them. It might be a good idea if we can go back and sort of have a look at some of these questions, if that's okay with everybody. Just ahead.
So by all means, Jerry, good idea. So I would just suggest to everybody, feel free to put your cameras back on and ask Jerry absolutely as many questions as you can before he goes. But just while people are thinking about those questions, it's really interesting to hear what you had to say, Jerry. The fact that IP can increase your sales. It enhances the value of your business, and we certainly hear about that. Just thinking, everybody hears about that on things like Dragon's Den, but we sort of know it, but we're not applying that knowledge. The best one of all, I like the reduction of corporation tax. So really interesting to hear. But Rita, any more questions from you?
Yeah, if I can. Sorry if there's other background noise. There's another call going on behind me. I basically just wanted to say, so there is companies with a similar name to the one I'm considering, but not the same. So I think in Safanic, the original name they chose was exactly like the one that someone else had. Is it still relevant then to consider for similar sounding?
Yes, it's definitely something you need to speak to someone such as myself about. How trademarks work is that the trademark registration gives the owner the power to prevent someone using the identical mark, but also any mark which is confusably similar. And this idea of confusable similarity, it's very case specific, but generally speaking, if you know of similar things, then you need to get an attorney to check that for you. It's a little bit difficult to advise in the UK because we have a system where if you apply for a trademark registration, the onus is on the owners of earlier trademark registrations to stop you. So the UK IPO doesn't stop you. It will allow your application to go through, but then a third party rights owner can oppose your application. So when we're advising people, we have to look at what's out there and try to gauge the risk. So the more different your mark is to other people's, the lower the level of risk. If it's very similar to a lot of marks that exist there already, then you have to go and look at who those people are. Are they using them? Are they big, well-funded US companies, or are they individuals or whatever? You engage the risk level. So often we will help people to move to a position where they do get the mark registered because that's what they really want, and they want to invest time and effort and money in trying to get it. And even if there are some bumps in the road, they will try anyway. Other times, the other option is to say, well, go away and think of something else. And have some fun with it, and throw us some examples, limit it down to sort of 3 that you a shortlist that you're interested in, and we can give a kind of a basic response. Yeah, that one looks good, that one doesn't. But it's all about trying to help you avoid problems initially, because you don't want to have a legal dispute. But then at the end of the day, you want to have as exclusive a mark as possible. You don't actually want to have a trademark which is like a lot of other people's trademarks, because then you don't have particular exclusivity. You want to have a brand which is very, very different to everybody else's, because that allows you more scope for protecting it and more memorability. People will like the brand, they'll interact with it, it'll resonate with them, and so on and so forth. So the more distinctive the brand, the better. So the Stefanik example is a really good example of someone coming up with a completely made up word, which right at the very beginning might have looked a bit odd, and they might have thought, well, I don't know if this is going to work, but they've made it work through their marketing and advertising and the designs and all that sort of thing. But now it's incredibly distinctive and it's very exclusive. There's nothing else really like it. And if anyone comes anywhere near it, we're able to stop them. So somebody had Surfganic for organic clothing, and we were able to stop them very, very quickly, because, you know, that's just too similar. Whereas, you know, if someone had just, you know, surf this or surf that, it's not so important. It doesn't matter to us if someone uses surf. So we don't take action against that. So it's not an easy question to answer in the abstract. But if you said to me, this particular example, am I going to be okay or not? I can give you a very clear idea of whether you are likely to be or not.
Okay, and if you don't mind, I just have one more question. I've got to pick someone up at the station, so I might need to pop off the call. Just a question around, so there's, you know, copyright assumes for sort of big pieces of work and writing of a book, but what about smaller things like articles? They do have knowledge, they do have sort of very specialized knowledge in them, and you might be doing it more frequent, so sending it out there in social media, but do they need any sort of protecting? They might be based on a big book,
yeah,
but
that's all of that's protected by copyright. Copyright protects works of art, which has been defined in various different ways, one of which is anything which takes efforts to create, but it doesn't subsist in a very minimal things like the title of a book or somebody's name. That's not a work. So a work's got to be more than that. I mean, would one sentence be a work? Possibly, probably not. But as soon as you get to like a paragraph or an article, that's clearly protected by copyright.
Oh, is it?
And copyright protects all photographs, all design images, anything like that you would create. So any kind of creative thing that took some effort to create that is a work of art is generally protected. It does have to be recorded. So there's some weird examples of certain sorts of art forms which disappear. You know, like if you make an art form in the sand and then the sea rolls in and destroys it, well, copyright doesn't protect it. It's just a weird exclusion. So you do have to make a copy of it. So it has to exist as a recorded thing. But in almost every case you can think of, that's the case.
Okay. All right. Thank you very much. Just going to hop off now. Thank you for this. Really informative.
Thank you, Risa, for your questions. Good one. Do we have any other questions that anybody would like to ask? Santosh, Matt, feel free to get typing again if you've got any questions. And I know, Matt, initially you were asking about software and a few other things. So I'm just wondering if we've answered your questions. Feel free to let us know. Santosh, anything from you that you would like asked?
Yeah, thank you. Yeah, my question was, you know, if someone is just starting up, which I am now doing, which is, you know, M&A advisory, so mergers and acquisitions, and a consulting business based on that. But if I were to, you know, talk about all the things that I offer on my website, it is not unique. It can be copied, and you know, whatever experience I have. Although it seems unique to me, how can I make sure that I protect? Is there any IP protection around the services industry?
Yeah, the most important thing for a business of that nature is the branding. So your particular name, which depending on the type of business it is, it might be common for somebody to have a particular type of name. So like law firms, for instance, are just going to tend to be surnames bolted together. If you are a business consultancy, it's quite common to have more distinctive branding. So the high-end business consultancy companies have quite distinctive branding. So essentially, it's important to just zero in on that and get that right. And when I say get it right, I mean get the trademark protection in place and make sure that we've got something distinctive and different enough from everybody else, but also get it right from a marketing and promotion point of view. What you want is for your target audience to immediately like the brand and immediately feel confident about it. So, you might zero in on who the target audience is. Does it happen to be male or female? What kind of age? What kind of other brands do those people already use? And you can see patterns emerging, and that might feed back into the sort of fonts you use, the sort of colors you use, all that kind of stuff. But the name itself is very, very important. If it's something that just sort of sounds a bit weak and clunky, then you're immediately just putting yourself as a disadvantage because your clients aren't going to like it so much. Whereas if it is something that sounds very corporate, professional, expert, then they're immediately going to feel happy about it. And that's also going to reflect on how your website looks and things like that. So it is really only really trademarks you need to be too concerned about. In terms of businesses like yours, we have a lot of clients in that space who like to use acronyms and have particular methodologies and things like that. Well, they're not the kinds of things that you can protect in the sense that you can stop other people doing them. But what you can protect is to have actual trademark registrations for some of those acronyms. So if you were to push a particular kind of product service and you were saying, well, and this is the name we've given it, and it's an acronym for this or some other name, then think of it in terms of your house trademark and your product trademarks. So if you think about something like Kellogg's is a house trademark, but then you have Frosties and cornflakes or whatever. So trademarks don't have to just relate to the actual business name, but also the other elements of it. So we have helped people register quite a lot of those things. And it gives them a position of power, because it just means that if it becomes almost like an industry standard or some kind of generic thing that people recognize, oh yes, I know that system, that, the name of that system. If it's a trademark registration, then you've got complete control of it. And other people who are using it, you can stop them using it. They've got to call it something else. So you can dig a bit deeper in terms of the branding protection that you've got. But otherwise, yeah, it's a business that you're in where there is no real way of stopping people competing with you. It's really about making your business better than everybody else's, and then protecting the bits of it that you can protect. Yeah. So I think you don't need to worry about patents and designs or anything like that. It's really just the trademarks that you want to get right. And you obviously don't want to have a situation where you step on someone else's toes, for instance, and there can be issues. So when it comes to these sorts of businesses, I tend to find that people aren't particularly inventive with the branding, but I can see why. But it's not a consumer product. You're not targeting children with sweets or something like that, where the branding has to be absolutely spot on. But it doesn't mean you shouldn't pay as much attention to it and get it right. You might as well get it right. There's no difference in cost for getting it right or wrong. You can choose something which we can protect, and that's is really going to work and push your business forward.
And for trademark, sorry, just one question. Does it have to go through an IP attorney like yours? No, and typically, for a startup or someone who's just beginning, what does it cost?
I would always advise that you do use an attorney, but the UK IPO in particular is very, very friendly to unrepresented applicants compared to other offices around the world. For example, in the US, you have to use a US attorney to file a US trademark application, but in the UK, you don't. And there is an online filing system that the UK IPO has, so you can use that. You just have to be wary that it's one of those things which the actual filing of an application using the online process of writing what the mark is and what you're going to use it to sell, it's very simple and straightforward, but that's not really where the complexity lies. The complexity lies in making sure that you're not filing something which isn't going to work, and making sure that you cover the right goods and services, which is a little bit of a dark art. So there are some complexities to it, but from a cost-wise point of view, I would encourage you to maybe shop around. There could be some people who are more expensive, less expensive, or whatever, or could do a deal or whatever. But when it comes to trademarks, just be slightly wary of people who will file trademark applications for you for a couple of £100, because they are literally doing what you can do yourself. So there are some firms out there that aren't attorneys. They're not charging you because they're lawyers. They just set up an online thing. Like I can't remember the name of them, but there's always some. Don't spend your money. Don't waste your money on that. Do it yourself. Because they're just going to do exactly what you tell them to do. So there's no point in paying them for that. What you would pay for someone like me is to do all the background stuff for you and to work out what the risk level is and to advise you. That's what you're really paying for.
Thank you, Jerry, and apologies that I need to draw things to a close right now. Thank you very much for your questions. Rita had to go. Matt, well done for sticking to the end of this session in difficult circumstances. We will be sending out the slides, and I'm sure Jerry would be very happy to take any direct questions after this meeting. Jerry, if you're happy to do that,
Yes, just my firm, as with many others, we do an hour's free consultation. So if you want to come and talk to me about anything, that doesn't cost you anything.
So that's great. So thank you very much, everybody, for joining us. Thank you, Jerry, for your time. Some really useful hints and tips
very helpful,
there.
very informative. Thank you so much.